You may recall that in its answer brief, the state of Florida argued that the majority of the arguments raised by Michael Offerman, the appellate attorney for Charles Adelson, were waived, and they were not properly preserved at the trial level by Dan Rochbaum and his team. So now we get to hear Michael Offerman's response to that counter-argument from the state in what is called the reply brief in the appeal for Charles Adelson. After the reply brief has been filed, the next thing in the process is for the appellate court to decide whether it's going to hold oral arguments in a case or not. In a case like this, it is likely that there will be oral arguments, and then we'll just have to wait for an opinion. All right, here we go. Here's Ed.
In the District Court of Appeal, First Appellate District of Florida, Charles Adelson, Appellant v. State of Florida. Michael Offerman, Laura Cornell Niles. Argument and citations of authority. The state's answer brief attempts to avoid the merits of Appellate Adelson's constitutional claims by failing to engage with the fundamental legal principles that underlie his arguments. Much of the state's discussion focuses on minor procedural points or characterization of isolated facts rather than confronting the broader constitutional concerns at stake, namely the right to a fair trial by an impartial jury and the right to a fair and complete presentation of a defense. The state's lack of substantive engagement with these core issues exposes the weakness of its arguments. Consequently, the state's brief does not demonstrate a sufficient basis for affirming the rulings that impacted the fairness and reliability of the proceedings below. For these reasons, each issue is addressed in turn with careful attention to the record and the law. 1. The trial court erred by denying Appellant Adelson's motion for a change of venue. Appellant Adelson continues to rely on the argument as outlined in the initial brief regarding Claim 1. Appellant Adelson maintains that after attempting to select a jury, it was clear that it would not be possible to convene a fair and impartial jury because of the extensive pre-trial publicity in Tallahassee. The trial court's error in failing to change the venue violated Appellant Adelson's rights under the United States and Florida Constitutions, see U.S. Constitution Amendment 6, Article 1, and subsection 16, Florida Constitution, see also United States v. Cabrales. Quoting, the Constitution safeguards the defendant's venue right. The state argues that Appellant Adelson waived his venue argument by accepting the jury without objection. In reply, Appellant Adelson relies on Manning v. State. Despite the state's assertion that Adelson's case was nothing like Manning, in that case, the Florida Supreme Court reversed on the venue issue where, quoting, the defendant did not exhaust his preemptory challenges and accepted the jury without renewing his motion for change of venue. In fact, defense counsel Robert Markel, prior to accepting the jury, stated, quote, it would appear to us that we have a fair and impartial jury here. Nonetheless, the Florida Supreme Court held that the motion for change of venue in this case was amply supported by evidence which established that the community was so pervasively exposed to the circumstances of this incident that the defendant could not secure a fair and impartial trial in Columbia County. The court cautioned, each case must be judged on its own merits as to whether under the circumstances the inhabitants of the community are so infected by knowledge of the incident and accompanying prejudice that jurors from the community could not possibly try the case solely on the evidence presented in the courtroom. Further, because our state and federal constitutions guarantee to criminal defendants a right to a fair trial by an impartial jury, the venue error is structural. That is, the denial of the motion to change venue is the injury itself and affects every subsequent moment of trial. The state's procedural argument is therefore incorrect as a matter of law. While it is preferable to renew the objection at the end of jury selection, renewal was not required here, just as it was not in Manning. Additionally, the state argues that Appellant Adelson's oral motion for change of venue was legally insufficient because Florida Rule of Criminal Procedure 3.240 requires the motion to be submitted in writing. Notably, in both cases cited by the state in support of this assertion, the Florida Supreme Court reached the merits of the venue argument. See Provenzano v. State, Holsworth v. State. Thus, Florida law does not require strict technical compliance with Rule 3.240 for an appellate court to review a venue ruling where the trial court was aware of the objection and denied relief, i.e., what matters is whether the trial court was presented with the issue and the opportunity to rule on it. Here, the trial court expressly entertained the oral motion, asked a question regarding counsel's suggested alternative venue, and proceeded to trial knowing that Appellant Adelson contended a fair jury could not be drawn from Leon County. Appellant Adelson asserts that appellate courts retained the discretion and, in appropriate cases, the obligation to reach the issue where fundamental fairness is implicated. The situation is directly analogous to the scenario described in Provenzano. Appellant contends that the trial court erred in failing to grant his request for change of venue. However, this issue has not been preserved for appellate review. The trial court granted leave to file an oral motion for change of venue on the first day of trial. The motion was taken under advisement with the condition that a written motion following shortly thereafter. No written motion was ever filed. This allegation has not been preserved for appellate review because the motion to change venue was neither written, as required by Florida Rule of Criminal Procedure 3.240 and requested by the judge, nor ruled upon by the trial court. We choose to address the substantive aspects of this issue, however, to allay any fear that appellant did not receive a fair trial. Just as in Provenzano, the concern here goes to the core constitutional guarantee of an impartial jury. Venue is not a technical or discretionary procedural matter. It is a structural safeguard. See Urban v. Dowd. When the record demonstrates a credible risk that a defendant was tried before a jury drawn from a community that had already formed a consensus as to his guilt, as it does here, the appellate court may and should consider the merits even if a procedural rule was imperfectly followed. Unlike other claims that may be forfeited by inaction, pretrial publicity and venue issues implicate the fundamental right to a fair trial under both the United States and Florida constitutions. When fundamental fairness is at stake, appellate courts routinely review such claims to ensure confidence in the verdict and in the judicial process itself. See Holsworth v. Provenzano. This court has a duty to review the record in its entirety in reviewing this claim, see Singer v. State. In quoting, in determining whether error was committed in the denial of the motion for change of venue, we are not limited to consideration only of the motion and traverse and the matters submitted in support thereof. We are permitted to consider the whole record and have done so, unquote. The record shows pervasive, community-wide prejudice born from nearly a decade of sensationalized local reporting, repeated discussions which tied the case to the identity of the community, and prospective jurors who either acknowledged bias or lied to conceal it, with some openly expressing a belief in guilt in the jury assembly room. This was not sporadic exposure, it was saturation. The state asserts that the pretrial publicity in Foster v. State was more inflammatory than any of the media coverage surrounding Adelson's case. The record does not support that characterization. As an initial matter, the pretrial publicity in Foster occurred in a pre-digital media era between 1996 and 1998, when coverage was limited to newspapers and scheduled television broadcasts. Additionally, unlike the defendant in Foster, who was tried around 2 years after the murder, the publicity in Appellant Adelson's case spanned 9 years, directly involved the local university community, and repeatedly promoted a narrative of the Adelson family as architects of a long-running plot. Simply put, the publicity in this case is materially different in degree, duration, and depth of local impact than the publicity at issue in Foster. The publicity in Appellant Adelson's case was not merely extensive, it was sustained, locally concentrated, narrative-driven, and personal. For nearly a decade before trial, the media repeatedly framed the case in terms of community grievance, academic loss, and the moral outrage of a murdered professor at a beloved local university. The coverage did not simply report developments, it amplified the exposure through podcasts, documentaries, social media commentary, and community forums, effectively intertwining the tragedy with a core civic identity of Leon County. Leon County residents did not simply recall the case, they had lived with it, discussed it, theorized about it, and absorbed into a shared cultural understanding of a local tragedy. That is precisely the type of saturation that Irvin, Shepard, McCaskill, Murphy, and Manning identify as such a pervasive nature that it threatens impartiality. The state also asserts that if Danny Rawling could receive a fair trial in 1994 Gainesville, then Adelson could receive a fair trial in 2023 Tallahassee. Again, Appellate Adelson respectfully disagrees. The state's reliance on Rawling overlooks the fundamental difference between the pre-digital media landscape of 1994 and the pervasive, self-amplifying media environment of 2023. In other words, the media environment of 1994 is simply not comparable to the media ecosystem of 2023. In Rawling, pretrial publicity occurred almost entirely through traditional news platforms such as local newspapers, nightly broadcasts, and limited national reporting. In 1994, once the newspaper was folded and the television was turned off, the story ended for the day. As such, coverage was episodic and finite. There was no 24-hour social media commentary, no podcasts revisiting the case, no algorithms sending repeated reminders, no discussion threads allowing community members to reinforce one another's views, and no streaming platforms releasing case-related content that are accessible on demand. The publicity ended at the edges of the printed page and the conclusion of the evening broadcast. It did not follow jurors home on their phones, computers, or social media feeds. It did not regenerate or amplify itself and was not algorithmically targeted to continuously reinsert the case into public consciousness. Here, by contrast, at the time of Appellant Adelson's trial, coverage of Dan Markel's murder had been continuous for nearly a decade and had proliferated across digital platforms that did not exist in 1994, including streaming documentaries, podcasts, YouTube commentary channels, Reddit true crime communities, and numerous social media platforms. Potential jurors reported drawing information from each of these sources and others, demonstrating the extraordinary reach and persistence of the coverage. Potential jurors in 2023 could not simply avoid coverage by not reading the newspaper or watching television. Exposure was persistent, shareable, and algorithmically reinforced, making prejudgment far more likely and far more difficult to screen out than in 1994. The qualitative difference in exposure is profound, and Rawling does not resolve it. The state asserts that the pretrial publicity did not originate either from the police or the state attorney's office. Appellant Adelson respectfully disagrees, but more critically, this argument misunderstands the constitutional inquiry. The question is not who lit the fuse, but how completely the fire spread. What matters is the degree of saturation, the tone of the coverage, and its effect on the venire. And the effect here was unmistakable. Here, the coverage indisputably favored the state's narrative. Voir dire revealed a community where the presumption of guilt had already been absorbed as common knowledge. 53 of 54 prospective jurors who had formed an opinion believed Appellant Adelson was guilty. That is not a neutral starting point. That is a verdict delivered by the community before the trial even began. Whether the initial spark came from a press conference by the state attorney or a local police, a podcast, documentary, or online commentary is irrelevant. What matters is that the prejudice was deep, widespread, and outcome-directing. See McCaskill. The test for determining a change of venue is whether the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely upon evidence presented in the courtroom. The state argues that Appellant Adelson's use of peremptory challenges somehow undermines the showing of community prejudice, asserting that Adelson's use of peremptory challenges also undermines his argument. Adelson did not use all 9 of his peremptory strikes until the end of jury selection, when he used his leftover peremptory challenges to back strike 2 prospective jurors. At this point, the state and Adelson had already accepted 12 jurors from the main jury. If the minds of Leon County residents were truly infected, then Adelson would have run out of peremptory challenges long before 12 jurors were seated. This argument is both unsupported in law and illogical in practice. First, peremptory challenges are not the mechanism for curing a tainted venire. Once a trial court denies a motion to change venue, as explained above, the injury is structural because the defendant is then forced to select a jury from a pool already exposed to prejudicial influence. Moreover, the law does not require a defendant to expend peremptory strikes in a particular order, under a particular strategy, or at a particular pace. Second, the state's premise is factually flawed. The voir dire record shows that more than 4 prospective jurors admitted to having already formed an opinion and believed Appellant Adelson was guilty before hearing evidence. The relevant inquiry is the condition of the venire as a whole, not the sequence in which counsel exercised peremptory strikes. Third, the state's assertion misunderstands the role of peremptory challenges entirely. Peremptory challenges are used to remove individual jurors. They do not and cannot remedy the systemic problem of venire infected by pervasive pretrial publicity. No number of successful peremptory challenges can cure a fundamentally biased jury pool. Additionally, Appellant Adelson exercised all of his peremptory challenges. Despite this, of the 12 jurors who actually sat in judgment of him, 8 had media exposure to the case in some manner. The problem here is not that Appellant Adelson failed to remove a particular juror. It is that he was forced to pick a jury from a community where guilt was already the dominant assumption. That is the very harm that a change of venue is designed to prevent. The state claims that Adelson cannot argue that his trial occurred in a small community. Appellant Adelson respectfully disagrees. Although the state cites census figures to compare Tallahassee's population to Gainesville's population, community size for venue purposes is not measured by raw population numbers, but by the likelihood that members of the community share exposure to the same news sources and public narrative. See Shepard and McCaskill. More importantly, the characterization of Tallahassee as a small community comes not from Appellant Adelson, but from the trial court itself. In granting defendant Charles Adelson's unopposed motion for protective order, the trial court expressly found the disclosure of these discovery materials would be big news in this small community, potentially infecting the entire jury pool, even those who at this point may be acceptable jurors. Those without an opinion at this time may form an opinion, thereby reducing the jury pool drastically. Thus, the trial court recognized precisely what Appellant Adelson argues, that Tallahassee is a small community where news regarding this case spreads quickly, is widely discussed, and such news has the capacity to contaminate the entire venire. The state cannot now claim that Tallahassee is too large to raise concerns about community saturation when it previously relied on the small community nature of Leon County to justify restricting public access to discovery to avoid infecting the jury pool. The trial court's finding regarding Tallahassee as a small community also underscores a key point in the venue analysis. This case was not just known in Tallahassee, it mattered to Tallahassee. That is the defining characteristic of a change of venue motion requiring relocation regardless of population size. Accordingly, the state's attempt to dismiss the small community concern is both inconsistent with the record and contradictory to its own prior litigation posture, where the prosecutor stated on the record that the state did not oppose Appellant Adelson's motion for a protective order because its main concern was to be able to try this case in Tallahassee, and therefore restricting media access to certain discovery material was warranted. In short, the trial court recognized the risk. The state did too. The voir dire record confirms that the risk materialized. The state did not respond in its answer brief to Appellant Adelson's argument regarding the two prospective jurors who misrepresented their impartiality to the court and parties during voir dire. This silence is telling. The state's answer brief contains no rebuttal to the following undisputed facts in the record. 1. A prospective juror affirmatively stated that he had no opinion about the case, yet had previously posted on social media that if he were the parent of the victim, he would want to kill co-conspirator Sigfredo Garcia. 2. Another juror represented that he had not formed an opinion regarding Appellant Adelson's guilt, but was overheard in the jury assembly room stating he's guilty in the presence of other potential jurors. These are serious misrepresentations that directly undermine the integrity of the jury selection process. They reflect exactly the scenario the case law describes, where pretrial publicity is so pervasive that jurors may profess impartiality in the courtroom while holding fixed opinions outside of it. See Patton v. Yount. Quoting, adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. This point is particularly significant because it shows that at least two prospective jurors affirmatively concealed their true views when questioned about their impartiality. When jurors misrepresent their opinions in court, the reliability of the entire voir dire process is called into question. If two prospective jurors were willing to deny previously held and expressed beliefs regarding Appellant Adelson's guilt, it is entirely reasonable and legally relevant to conclude that other biased jurors may have been seated despite expressing assurances of neutrality. This is the heart of the venue issue. The constitutional harm lies not only in the pretrial publicity, but in the demonstrated inability of voir dire to screen out its effects. The state's decision not to address these jurors in its answer brief underscores this point. If the state believed these incidents were insignificant, it would have said so. Its silence operates as a tacit acknowledgement that these facts powerfully undermine its claim that an impartial jury was selected in Leon County. The record reflects a community atmosphere so infused with belief in Appellant Adelson's guilt that some jurors felt compelled to conceal their prejudgment in order to serve. As the United States Supreme Court has recognized, our system of law has always endeavored to prevent even the probability of unfairness. See Shepard, quoting the language of Justice Black for the court in re Murchison. With his life at stake, it is not requiring too much that petitioner be tried in an atmosphere undisturbed by so huge a wave of public passion and by a jury other than one in which 2/3 of the members admit, before hearing any testimony, to possessing a belief in his guilt. See Urban, citing Strobel v. State of California, Shepard v. Florida, Moore v. Dempsey. These principles apply in full force here. The law strives to avoid even the probability of unfairness, and a trial cannot be fair when the community has already reached a verdict before a single piece of evidence is presented. The threat to fairness becomes even greater where prospective jurors conceal their preformed beliefs during voir dire in such circumstances as here. A change of venue was necessary to protect Appellant Adelson's constitutional rights. Accordingly, a new trial is required. 2. The trial court erred by denying Appellant Adelson's motion to strike the venire panel after several potential jurors reported to the court and the parties that other potential jurors were having conversations about the case after being instructed not to do so. As to Claim 2, Appellant Adelson continues to rely on the argument in the initial brief. The record reflects multiple independent reports that prospective jurors were discussing Appellant Adelson's case, including expressions of guilt, after being specifically instructed not to do so. Under these circumstances, the trial court's refusal to strike the Venire panel was an abuse of discretion. The state's argument that Appellant Adelson affirmatively accepted his jury without objection ignores the multiple contemporaneous motions and renewals of the motion to strike the Venire throughout voir dire. Defense counsel moved repeatedly to strike the panel as more reports of improper discussions and premature judgments emerged. This is not a case where a single early objection was abandoned. Rather, the defense renewed its objection multiple times, each time prompted by newly revealed misconduct within the panel. The record plainly reflects an ongoing, preserved objection that a particular section of the Venire was tainted. The state's reliance on Johnson v. State and Hayes v. State is unpersuasive. In those cases, the defendants failed to renew or maintain their objections after voir dire concluded, leaving open the possibility that the objections had been abandoned. Here, by contrast, defense counsel objected and renewed the motion multiple times during voir dire while the prejudice was unfolding, and the trial court expressly ruled on each one. There was nothing further to renew after the court denied the motions and proceeded to trial. See also Caratorelli v. State. Quoting, under our cases, the preservation of a challenge to a potential juror requires more than one objection. Here, defense counsel did make more than one objection motion, and therefore the motion was renewed before the jury was sworn, i.e. multiple times during voir dire. Appellant Adelson also notes that the circumstance in this case does not pertain to the preservation of a challenge to one specific potential juror, but to an entire section of jurors who were exposed to impermissible content or committed misconduct themselves. Relatedly, the state's procedural argument under Florida Rule of Criminal Procedure 3.290 also fails. The state argues that Appellant Adelson's oral motion was legally insufficient because Adelson failed to comply with Rule 3.290. Rule 3.290 states, the state or defendant may challenge the panel. A challenge to the panel may be made only on the ground that the prospective jurors were not selected or drawn according to law. Challenges to the panel shall be made and decided before any individual juror is examined unless otherwise ordered by the court. A challenge to the panel shall be in writing and shall specify the facts constituting the ground of the challenge. Challenges to the panel shall be tried by the court. Upon the trial of a challenge to the panel, the witnesses may be examined on oath by the court and may be so examined by either party. If the challenge to the panel is sustained, the court shall discharge the panel. If the challenge is not sustained, the individual jurors shall be called. Plainly, Appellant Adelson did not assert a challenge to the panel as contemplated by the rule. The purpose of the rule is to address irregularities in the formation of the jury panel itself, such as the systematic exclusion of a class of persons based on race, sex, ethnicity, religion, or similar characteristics. See generally Gordon v. State. Quoting, while defendants are not entitled to a particular jury composition, jury wheels, pools of names, panels, or venires from which jurors are drawn must not systematically exclude distinctive groups in the community and thereby fail to be reasonably representative thereof. Simmons v. State. It is crystal clear, that in making up the jury list there was an intentional and systematic exclusion of common laborers as a class. Unquote. By contrast, Appellant Adelson's motion sought to strike a portion of the venire, specifically jurors 51 through 102, not because of any illegality in the panel's formation, but because those jurors either 1. Violated the court's directive not to discuss the case, or 2. Were exposed to comments from other prospective jurors who violated the court's directive not to discuss the case. It was not possible to make the motion to strike the panel or rule upon it before any individual juror is examined, because it was the voir dire examinations themselves that revealed the misconduct. Accordingly, Rule 3.290 was not implicated, and Appellant Adelson was not required to submit the motion in writing to preserve the issue for appellate review. Additionally, the grounds for the motion stated by the trial counsel were factually specific and made on the record, which ensured that the trial court and opposing counsel were aware of the factual basis for the challenge. The trial court and state both responded to the substance of the motion, leaving no doubt it is properly before the court. See Steinhorst v. State, quoting, "In order for an argument to be cognizable on appeal, it must be the specific contention asserted as legal ground for the objection, exception, or motion below," unquote. Accordingly, this court may review the issue on appeal. See State v. Calvert. Quote, "The purpose of the contemporaneous objection rule is to place the trial judge on notice that error may have been committed and provides him an opportunity to correct it at an early stage of the proceedings. Objections may be preserved on the basis that their purpose is clear from the context," unquote. The trial court abused its discretion when it refused to strike the panel of tainted jurors. The issue was preserved, as explained above, and thus the correct standard is abuse of discretion. Nonetheless, Appellant Adelson contends that the error amounts to fundamental error because it cannot be said that the guilty verdict could have been obtained without the error. CFB v. State, quote, "The sole exception of the contemporaneous objection rule applies where the error is fundamental," unquote. In other words, even if this court were to apply fundamental error review, the result is the same. An error is deemed fundamental when it goes to the foundation of the case or the merits of the cause of action and is equivalent to a denial of due process, JB v. State, citing State v. Johnson. The pervasive nature of the improper discussions here meets that standard. The state minimizes what occurred by labeling the misconduct as isolated comments. The record tells a different story. Jurors repeatedly reported that other potential jurors were openly discussing the case, sharing details, and expressing opinions of guilt despite explicit court instructions not to do so. At least 3 distinct prospective jurors confirmed these violations, each describing different speakers, conversations, and opinions. One juror stated that people were discussing the case all day. Another heard someone say, "I think he did it." This was not a single rogue remark. It was a pattern of disobedience and premature deliberation across multiple potential jurors. In response, the trial court reiterated its admonition to the panel and removed a few identified jurors for cause. But, as defense counsel correctly observed, this did not cure the problem. We have no idea who this young man said was within earshot of, or how many others were affected. In short, nothing in this record supports the state's assertion that Appellant Adelson received a fair trial from well-mannered, untainted jurors. When misconduct permeates the venire to this degree, the court's admonition could not restore the presumption of impartiality that the Sixth Amendment requires. Given repeated reports of improper juror discussions and admissions of guilt opinions, the trial court's decision to proceed with the tainted venire was unreasonable. The court recognized the problem, warned the panel, and removed some jurors, but declined to address the broader contamination. That half measure failed to safeguard Appellant Adelson's constitutional right to an impartial jury. Allowing a tainted jury panel to remain intact violated Appellant Adelson's constitutional right to a fair and impartial jury and deprived him of his right to a fair trial. See U.S. Constitution Amendments 5 and 14, Article 1, Subsection 9, Florida Constitution. Appellant Adelson's convictions must be reversed and remanded for a new trial before an untainted jury. 3. The trial court erred by excluding defense-proffered text messages that would have shown Appellant Adelson and other alleged co-conspirators communicating normally during the time leading up to Dan Markel's murder to rebut the state's contention that Appellant Adelson and alleged co-conspirators were making phone calls about the murder during the relevant time period. As to Claim 3, Appellant Adelson relies on the argument outlined in his initial brief. The state responds that none of the text messages Adelson sought to introduce into evidence contained any relevant information. Also, some of Adelson's texts contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. In any event, Adelson suffered no harm because he testified about the content of his text messages. Appellant Adelson respectfully disagrees with each of these points. The state's claim that Appellant Adelson invited the error because he did not proffer individual text messages mischaracterizes both the record and the nature of the trial court's ruling. The record reflects that defense counsel sought to introduce the messages collectively as a single exhibit, offered not for the truth of the matters asserted, but to rebut the state's multiple inferences that phone communications between Appellant Adelson and others around the time of the murder related to the murder itself. Because the state presented its phone call evidence as a pattern or composite rather than individually, the defense needed to enter the text messages in the same collective format to provide a meaningful rebuttal. Counsel expressly articulated the relevance of the messages, which was to demonstrate that Appellant Adelson and the alleged co-conspirators were communicating normally about work and daily life rather than criminal activity. That the trial court suggested to the defense that it could, instead of offering the composite exhibit, enter specific text messages, and that defense counsel ultimately declined to do so, did not invite the error, as suggested by the state. Invited error occurs when a party induces the trial court into error or affirmatively agrees to the challenged ruling, see White v. State, holding that the defendant cannot take advantage on appeal of the situation he created at trial, citing McCrae v. State. The trial court's statement that, if there are portions again that are specifically relevant to negating either the motive or any of the elements of the charges and are not hearsay, as argued by the defense, I will consider those separately. But as a composite, on the whole, the 403 issues, the relevance and hearsay issues, I believe, compel me to deny their admission. Transcript 1593 did not transform the exclusion into an invited error. Once the trial court excluded the composite on hearsay, relevance, and prejudice grounds, further individual offers would have been futile. Simply put, invited error occurs when a party induces or acquiesces to a ruling they later contest, which is not the situation here. The purpose of introducing the composite exhibit of text messages was to show the pattern of ordinary, non-criminal communication between Appellant Adelson and the alleged co-conspirators during the critical time period surrounding Dan Markel's murder. The exhibit was not offered to prove the truth of any statements, but rather to demonstrate that, contrary to the state's suggestion, the communications consisted of routine discussions about work, family, and personal matters, and did not indicate planning, coordination, or awareness of the murder of Dan Markel. That alone established the relevance of the evidence. It directly rebutted the state's inference that phone communications during the same time frame were conspiratorial or connected to the murder, evidence that tends to disprove an essential element of the state's theory or that creates a reasonable doubt regarding participation in a crime is squarely within the scope of relevant evidence. See subsection 90.401 Florida statutes. In response to the state's assertion that the evidence lacked relevance, Appellant Adelson turns to the well-reasoned decision of the 2nd District Court of Appeal in Mateo v. State. There, the 2nd District explained, Florida law is clear that where evidence tends in any way, even indirectly, to establish a reasonable doubt of defendant's guilt, it is error to deny its admission. Rivera v. State. This principle is based in part on the U.S. Supreme Court's holding that few rights are more fundamental than that of an accused to present witnesses in his own defense. Chambers v. Mississippi. Thus, a general proposition, any evidence that tends to support the defendant's theory of defense is admissible, and it is error to exclude it. Dean v. State, Vanier v. State. Further, while the defense is bound by the same rules of evidence as the state, the question of what is relevant to show a reasonable doubt may present different considerations than the question of what is relevant to show the commission of the crime itself. Vanier. Thus, in Vanier, the court held that it was error for the trial court to have excluded evidence of letters written by the victim that tended to show that she was depressed and thus arguably supported the defendant's theory that the victim was not murdered but instead committed suicide. Similarly, in Bertram v. State, this court held that it was error for the trial court to refuse to permit the defendant to cross-examine a witness as to prior altercations between the defendant and his father when the theory of defense was that the father had set up the defendant in retaliation for the altercations. Likewise, in Dean, the court held that it was error for the trial court to refuse to permit the defendant to introduce a pawn slip when the defense theory was that the person who pawned the jewelry rather than the defendant was the perpetrator of the robbery. In this case, Mateo's theory of defense was that the jail officials were biased against him because he had been vocal about jail conditions in the past and that they made up the story about the lunch tray and the shank to cover up their misconduct. The audio tape in question does provide some evidence that supports this theory. The jail employee indicated that Mateo was placed in lockdown based solely on his past behavior and that she would be moving Mateo to a different facility so that the supervisor won't go after him. These statements, made by an employee of the jail where the incident occurred, provide at least some evidence of a pre-existing animosity between Mateo and the jail officials. This animosity, in turn, could provide evidence of a bias against Mateo by the jail officials that might affect the jury's assessment of their credibility and or their recollections and interpretations of the events supporting the charges. Thus, the audio tape was relevant in that it tended to support Mateo's defense, and the trial court erred in excluding it from evidence. See Mateo. Applying the principles explained in Mateo, the trial court in this case similarly erred in excluding evidence that appellant Adelson regularly communicated with the alleged co-conspirators and that they were communicating normally about work and daily life rather than conspiring to commit the murder during the time leading up to the murder. Just as the excluded evidence in Mateo tended to show bias and animosity that could support the defendant's theory of defense, the evidence of appellant Adelson's normal communications was directly relevant to appellant Adelson's theory that he did not conspire with others to commit the crime, but was later blackmailed into paying money to Catherine Magbanua, who in turn paid the killers. Critically, some evidence supporting the theory of defense is sufficient to warrant admission. Mateo. Here, even modest evidence that appellant Adelson communicated normally during the relevant time period was enough to support the defendant's claim that appellant Adelson was 1. Not involved in soliciting Magbanua, Rivera, or Garcia to commit the murder, 2. Conspiring with Magbanua to commit the murder, or 3. Guilty as a principal to the murder itself. By presenting the jury with the substance of the messages, the defense sought to show a lack of pattern of criminal intent and to illuminate appellant Adelson's state of mind. In urging the trial court to admit the exhibit, defense counsel articulated the relevance of the messages to appellant Adelson's state of mind. His state of mind is not that he's going to commit a murder. His state of mind is his normal, everyday activity. My life is the same as it was in February. I'm not talking about a murder. I'm not worried about anything. I'm living my life. That's what these text messages show. The state also contends that the exclusion of the messages did not prejudice appellant Adelson. Respectfully, appellant Adelson submits otherwise. By barring the defense from presenting this evidence, the trial court deprived Appellant Adelson of the opportunity to fully present his defense and to challenge the prosecution's narrative that he and Magbanua were communicating about the murder. Like the evidence in Mateo, this information was not peripheral. It was central to the jury's assessment of reasonable doubt and to Appellant Adelson's constitutionally protected right to present a complete defense. Accordingly, the trial court's ruling constitutes reversible error. The state argues that the composite text message exhibit contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. Further, the state argues that the texts would have likely angered the jury. But this misses the point. Appellant Adelson deliberately sought the admission of the exhibit, fully aware that some messages contained offensive language. Footnote 5. During the trial, the following was said. The court: the other concern I have with this is it would possibly cast even your client in a bad light. It was good seeing you, Negro. I think he called Miss Magbanua at one point a strong black woman. I don't know if there's any references to the N-word or other things in here. There were with other witnesses, but this is going to be a look at your own risk, Mr. Rashbaum. I understand, Your Honor. The court: please review to find the most relevant nuggets to go to the actual state of mind. Mr. Rashbaum: okay, they all go to state of mind. End footnote 5. He understood the potential for embarrassment, yet chose to try to introduce the messages because their probative value, showing normal, everyday communications and rebutting the state's inference of criminal intent, far outweighed the risk of discomfort or prejudice to himself. In other words, Appellant Adelson made a strategic decision to prioritize his constitutional right to present a defense over the concern about personal embarrassment. That some of the text messages may have contained language or content that could have embarrassed Appellant Adelson does not make their exclusion proper. Appellant Adelson's willingness to risk personal embarrassment in order to present relevant exculpatory evidence underscores, not undermines, the legitimacy of his position. Footnote 6. As an aside, by way of connection, back to the doctrine of invited error, Appellant Adelson notes that had the exhibit been admitted and Appellant Adelson later complained on appeal that the messages embarrassed or prejudiced him because they're sexual, racist, or other offensive references, that argument would have amounted to invited error. End footnote 6. The trial court excluded evidence that Appellant Adelson affirmatively wanted the jury to see the support his defense. The trial court's exclusion of the text messages violated both the evidence code and Appellant Adelson's constitutional right to present a defense. The proffered texts were relevant to rebut the state's inference that communications between Appellant Adelson, Magbanua, and members of his family concerned the murder. See subsection 90.401 Florida statutes. Evidence is relevant if it tends to prove or disprove a material fact. The error undermines the confidence in the outcome of the trial and goes to the very foundation of the case. See Everett v. State. The state's assertion that the jury would have been unsurprised to learn that Adelson did not text about the plot to kill Markel also misses the evidentiary point. The jury's hypothetical lack of surprise at the absence of incriminating statements cannot render otherwise relevant and exculpatory evidence inadmissible. See subsection 90.401 Florida statutes. Moreover, the state cannot both imply that Appellant Adelson's communications, the chain of traffic of phone calls, supported its theory of guilt, and then argue that the actual content of communications between the same people is immaterial. Footnote 7. Defense counsel identified the inconsistency. Mr. Rashbaum, just for the record, in the state's case in chief, they were allowed to put in phone calls showing the arrows indicating that they have no idea anything said on these calls. They're essentially the same thing as putting in text messages like this, except you actually see the content, right? The court. The chain of the traffic versus what is actually said. Mr. Rashbaum. They put in every call. Okay, they put in every call between these participants on those particular dates, which, by the way, correspond mostly to the days that I'm offering these text messages for. They put them in for their own purposes. I think I should be allowed, under a 403 analysis, what's good for the goose is good for the gander, to put in the text messages to show the pattern or lack of pattern of anything. But that's what these text messages show. But I can just ask the questions, but I would like the record to reflect that under a 403 analysis, it was allowed for them. It's not being allowed for us, the court. I wouldn't exactly say it boils down to being that simple, but your objection is noted, specifically as to what the state was permitted to demonstrate in their case in chief goes to either demonstrating motive or direct evidence of what they believe show the elements of the charges. As to these composite exhibits, and again, I don't want to get very deep into what the subject matter is, there are messages that either go to embarrassing of the other witnesses or litigants in this matter, matters that are wholly irrelevant, or matters that do not demonstrate in any way the theory of defense as the court understands it. If there are portions, again, that are specifically relevant to negating either the motive or any of the elements of the charges and are not hearsay as argued by the defense, I will consider those separately. But as a composite on the whole, the 403 issues, the relevance and hearsay issues, I believe, compel me to deny their admission. Mr. Rashbaum. Thank you, Your Honor. End footnote 7. Once the state invited the jury to draw inferences from the existence and timing of those communications, fairness required that the defense be permitted to introduce the content to place the inferences in their proper context. Excluding the messages deprived the jury of the best and most direct evidence of what those communications truly were, i.e., ordinary, not conspiratorial. Finally, the state asserts that Appellant Adelson was not harmed by the exclusion of his proffered evidence because he testified about the text messages. Respectfully, Appellant Adelson does not share the state's view. A defendant's own testimony is no substitute for contemporaneous documentary evidence that objectively corroborates the theory of defense. Jurors could reasonably view a defendant's testimony as inherently self-interested, whereas the text messages themselves would have provided independent, contemporaneous proof of his state of mind and shown the ordinary, non-criminal nature of his communications to rebut the state's claims that Appellant Adelson was planning a murder with the people with whom he communicated. Further, Appellant Adelson's testimony was only a fraction of the evidence necessary to support the defense theory. The trial court's exclusion of the text messages, which would have provided some evidence that he regularly communicated with the so-called co-conspirators not about the murder, effectively left Appellant Adelson with no meaningful evidence to present to the jury in support of his defense. See Mateo. Such a decision is generally considered harmful error. See Zanichi v. State, finding exclusion of the defendant's only proffered evidence in support of his defense to be harmful error. The exclusion of the text messages evidence violated Appellant Adelson's fundamental right to present a complete defense and left the jury with an incomplete and misleading picture of the interactions at the heart of the case. The resulting prejudice was substantial. On one hand, the state was permitted to introduce a pattern of phone calls and argue to the jury, footnote 8. Significantly, the state emphasized this argument in its closing. Ms. Kappelman. The communication records tell us a few other things, too. That's the June trip, July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Catherine Magbonawa to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Catherine Magbonawa was consistent with traveling on her way back from Comfort Rental Car, where the first rental car was rented, to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and has a 25-minute conversation. Continuing, on the day of the murder, we have communications between our parties, as listed here with the red line representing time of the murder. This flurry of calls between our persons of interest demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Catherine Magbonawa, to Garcia, and back. Continuing, so we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators, and each time we have a big event in this case, we see these call flurries where all the parties are calling each other in that structure that I had talked about. It goes from this one to this one to this one, but as the defense points out, these folks had independent relationship with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the murder or if these call flurries around these key evidence are just a coincidence? A conspiracy can be shaped like a cluster with everybody talking to everybody. It can be shaped like a wheel with one central hub talking to all the different spokes, or it can be shaped like a train car, which is what we have here, where one person talks to only the person, the car in front of them, and the car behind them. End footnote 8. And argued to the jury that they reflected communities related to the murder. On the other hand, Appellant Adelson was precluded from rebutting that claim with direct evidence that would have done so. The error was not harmless. Florida appellate courts have consistently held that an error is not harmless when the evidence that is the subject of the error is highlighted or emphasized by the state during closing arguments. See Martinez v. State, quoting, "We cannot find the improper opinion of guilt testimony to be harmless beyond a reasonable doubt, especially when it was again highlighted in closing arguments," end quote. Allen v. State. The fact that the state emphasized this erroneously admitted evidence in its closing argument also may have tainted the validity of the jury's verdict. The improper exclusion of the text messages resulted in a violation of Appellant Adelson's constitutional right to a fair trial. See U.S. Constitution Amendments 5 and 14, Article 1, Subsection 9, Florida Constitution. Appellant Adelson is therefore entitled to a new trial. 4. The trial court erred when it excluded evidence that was highly probative to the theory of defense, which was relevant and both non-hearsay and accepted from the hearsay rule, i.e. a recorded phone call from 2016 in which Appellant Adelson references a past extortion. As to Claim 4, Appellant Adelson continues to rely on the argument made in the initial brief. In its answer brief, the state argues that the excluded evidence was hearsay, not subject to a hearsay exception, and the exclusion did not prejudice Appellant Adelson. For the reasons set forth below, Appellant Adelson respectfully disagrees. The state's argument regarding hearsay rests on the mistaken premise that Appellant Adelson offered his statement, the phone call, and specifically the quote, "It's not done like that," for the truth of the matter asserted. The record demonstrates otherwise. The defense did not seek admission of the recorded phone call to prove that extortion generally occurs in a particular manner. Rather, the statement was offered to show Appellant Adelson's contemporaneous belief and state of mind, specifically that the people confronting his mother were not the same individuals who had previously extorted him following Dan Markel's murder. This belief directly supported the defense theory that Appellant Adelson was a prior victim of extortion related to the murder and not a participant in a conspiracy to carry it out. Section 90.803 paren 3 Florida statutes provides 3. Then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health, when such evidence is offered to 1. Prove the declarant's state of mind, emotion, or physical sensation at that time, or at any other time when such state is an issue in the action. 2. Prove or explain acts of subsequent conduct of the declarant. B. However, this subsection does not make admissible 1. An after-the-fact statement of memory or belief to prove the fact remembered or believed unless such statement relates to the execution, revocation, identification, or terms of the declarant's will. 2. A statement made under circumstances that indicate its lack of trustworthiness. Subsection 90.803 Florida statutes. As such, the offered evidence was an out-of-court statement offered to show appellant Adelson's beliefs, impressions, and or reactions, and it is captured by Section 90.803 as a hearsay exception. Additionally, because the statement was not offered for the truth of the matter it asserted, it was not hearsay or non-hearsay. See Fields v. State. Utterances which circumstantially indicate a specific state of mind causing them do not constitute hearsay. Here, the defense explicitly explained that the statement was relevant to appellant Adelson's belief, i.e. his mental state at the time of the bump, that law enforcement, not his prior extortionists, were behind the contact. This was a central factual dispute in the case because the state's theory was that no prior extortion ever occurred and that appellant Adelson's payments were part of a murder-for-hire scheme. By contrast, appellant Adelson maintained that his money reached the killers only because he was being extorted by them in the aftermath of the homicide. Because the statement was not offered for its truth, the hearsay rule does not apply. Footnote 9. The state argues that appellant Adelson cannot raise a non-hearsay argument on appeal because at trial defense counsel relied on a hearsay exception, state of mind, to support admissibility. However, the trial court sustained the state's hearsay objection, ruling that the evidence was inadmissible as hearsay. Consequently, that ruling is properly reviewable by this court. It is clear from the record that the proffered evidence was not offered for the truth of the matter asserted, and as such is non-hearsay. The trial court's exclusion of the evidence as hearsay, pursuant to the state's hearsay objection, cannot be insulated from review as to whether it was hearsay to begin with, merely because defense counsel invoked a hearsay exception. A statement excluded as hearsay that is non-hearsay remains reviewable. Additionally, the trial court's focus on whether appellant Adelson was qualified to opine on how extortion is done reflects a misunderstanding of the evidentiary purpose for which the evidence was offered. Appellant Adelson asserts that this court may review the trial court's determination on this matter. The statement was not being used as expert opinion or as factual assertion about extortion practices. Rather, it was offered to illuminate appellant Adelson's subjective perception and state of mind at the time of the 2016 bump incident, specifically his belief that the people contacting his mother were not the same individuals who had previously extorted him. By insisting on a foundation for opinion evidence, the trial court conflated the admissibility standard for expert testimony with the much broader standard of evidence of a party's mental state, thereby erroneously excluding highly relevant testimony that bore directly on appellant Adelson's defense theory. The trial court's mischaracterization of the statement as an opinion requiring qualification deprived the defense of the opportunity to present extemporaneous, corroborating evidence of appellant Adelson's state of mind, which was both probative and material to a central issue at trial. End footnote 9. Alternatively, the statement qualified under the state of mind exception, subsection 90.803 Florida statutes, as evidence of appellant Adelson's then existing mental feeling or belief. The state argues that Adelson wanted to use his statement to show that he had been extorted in the past, but the state of mind exception to the hearsay rule only encompasses future conduct, not prior conduct. See Reed v. State. Appellant Adelson respectfully disagrees with the state's characterization. The proffered evidence was a contemporaneous expression of appellant Adelson's belief as the events of the bump unfolded. Appellant Adelson's recorded words were made during the 2016 bump incident and therefore squarely fit within Section 90.803 Appellant Adelson agrees with the state that a hearsay statement which recounts observations made previously is by definition an after-the-fact statement of memory are expressly excluded from the state of mind exception. But that is not the circumstance here. Here, Appellant Adelson did not recount past events reflecting on what he previously thought or experienced, but instead made a contemporaneous expression of belief that law enforcement, not his prior extortionists, were behind the contact at the time of the bump occurred because of his past experiences with extortion. Nor was Appellant Adelson's attempting to use the state of mind exception to explore the state of mind intention or motive of anyone other than himself. The state asserts that Appellant Adelson attempted to offer the evidence to prove that Garcia or Magbanua extorted him. That characterization is also incorrect. Appellant Adelson's statement was offered solely to show his own contemporaneous beliefs and perceptions, specifically that he understood the individuals contacting his mother during the 2016 bump to be different from the people who had previously extorted him. The statement was therefore properly framed as evidence of Appellant Adelson's state of mind, not as evidence of another person's actions, intentions, or motives. But this observation is directly tied to the statement's role in supporting the defense because it captured Appellant Adelson's immediate perception during the 2016 bump. The recording independently corroborated the defense theory that he had been previously extorted by Dan Markel's killers. Importantly, as explained above, the statement was not offered to prove that Garcia or Magbanua actually extorted him. Rather, it was offered to show that in 2016, Appellant Adelson made a contemporaneous statement acknowledging that he had been extorted. The timing is significant because it occurred many years before his arrest, long before any motive to fabricate, and thus it carried exceptionally evidential weight. Unlike testimony presented years later at trial, the recorded statement reflected Appellant Adelson's contemporaneous understanding of events and lent credibility to his account. By excluding this evidence, the jury was left with only Appellant Adelson's trial testimony without the benefit of a contemporaneous record affirming his claims. Footnote 10. Once again, the state highlighted this in closing, arguing that multiple times that there is no evidence of the extortion and that Appellant Adelson made it up as a defense for trial. Mrs. Kappelman. He doesn't say, no, I have no general idea what you're talking about. He says, all right, he absolutely does have a general idea when she's talking about. And if they were innocent, as the defendant has claimed, and this was, in fact, a second extortion attempt, there is not a reason in the world why they wouldn't just say that. I got approached by another one. One came and paid me a visit today. It's happening again. That's crazy. That's his response. And I'm not adding the emphasis on that syllable. He says it like that. That's crazy. Why is it crazy? You're already being extorted by Latin King members. Remember, Doctor? It's because he hadn't come up with that part yet. Continuing, but at no point does he acknowledge the first extortion in the Dolce Vita meeting. Why? Why not? Oh, because she asked me not to talk about it. Well, times have changed. There's a second extortion effort now, and they're approaching my mother. You think I'm not going to mention the first extortion? Your people have been running their mouths, and now they've tracked down my mother. You need to get this under control. Nothing like that. Continuing, he's explaining to her that the problems with paying a potential extortionist, what he doesn't say, which is what you expect if he'd been getting extorted for 2 years, is Garcia or whoever you've been giving money to has obviously been running their mouths, and now they are messing with my mother. Continuing, the defendant hoping it's the police and saying, quote, these people only know part of the story or they think they know part of the story. The defense picks that out and says, oh, there he is talking about the first extortion. Or is he saying, why did they go to my mom instead of me? And footnote 10. Had the jury heard the statement, it would have materially influenced their evaluation of his credibility and the plausibility of the defense. This demonstrates that the erroneous exclusion of the evidence was highly prejudicial and undermined Appellant Adelson's right to a fair trial. As in Claim 3, the error was not harmless because the subject of the error was highlighted and emphasized by the state during closing. See Martinez, Allen. Additionally, as in Claim 3, the fact that the appellant Adelson testified to the content of the excluded evidence did not render its exclusion harmless because appellant Adelson's own testimony is no substitute for contemporaneous documentary evidence that objectively corroborates the theory of defense. Jurors could reasonably view a defendant's testimony as inherently self-interested, whereas the recording itself would have provided independent, contemporaneous proof of his state of mind and shown that in 2016, long before his arrest for these offenses, appellant Adelson made a statement indicating a previous extortion. This would have rebutted the state's claims that appellant Adelson made up the extortion defense, which was a theme during closing argument. The state makes an additional argument, specifically that other phone calls between Adelson, Magbanua, and Garcia disproved Adelson's story about being extorted. This argument does not engage with the critical evidentiary considerations at issue. The existence of contrary evidence in the record does not render otherwise admissible evidence inadmissible. Evidence that supports a party's theory is not negated, and its exclusion is not harmless simply because other evidence might appear inconsistent or contradictory. Rather, it is the jury's role to weigh conflicting evidence and assess credibility. Moreover, the exclusion of appellant Adelson's contemporaneous statement in the face of admitted evidence that could be interpreted against him actually exacerbates the prejudice. By denying the jury access to the 2016 recording at issue while allowing other calls to be admitted, the trial court deprived the defense of an important tool to corroborate the theory of defense with appellant Adelson's perception at the time to allow the jury to fully evaluate the credibility and plausibility of his account. In other words, the exclusion did not merely prevent repetition of evidence, it eliminated uniquely probative, corroborating testimony that was essential to the defense theory. Accordingly, for the reasons set forth above, the trial court erred by excluding appellant Adelson's statement from the 2016 recorded phone call. The improper exclusion of the call resulted in a violation of appellant Adelson's constitutional right to a fair trial, see U.S. Constitutional Amendments 5 and 14, Article 1, Subsection 9, Florida Constitution. Appellant Adelson is therefore entitled to a new trial. 5. The errors cumulatively in this case denied appellant Adelson his constitutional right to a fair trial. Appellant Adelson asserts that, in light of the errors set forth above, he was denied his constitutional right to a fair trial. See U.S. Constitutional Amendments 5 and 14, Article 1, Subsection 9, Florida Constitution. The state's contention that appellant Adelson's cumulative error claim fails because his individual claims are allegedly procedurally barred, meritless, or both, misinterprets the nature and impact of the errors. Claims 1 and 2 cumulatively affected appellant Adelson's right to a fair trial and impartial jury in violation of both the United States Constitution and the Florida Constitution. Claim 1 demonstrates that the trial court erred by denying appellant Adelson's motion for a change of venue despite pervasive community-wide pretrial publicity and a venire saturated with preconceived opinions of guilt. Claim 2 shows that the trial court compounded this error by refusing to strike the venire panel after multiple prospective jurors engaged in discussions about the case in violation of explicit court instructions. Taken together, these errors materially undermined the fairness of the trial because not only was the jury drawn from a prejudiced community, but that prejudice was actively reinforced through juror misconduct that went unremedied. The cumulative effect of these errors deprived appellant Adelson of the constitutional guarantees of due process and trial by an impartial jury. and the evidentiary errors explained in Claims 3 and 4 cumulatively deprived Appellant Adelson of critical evidence central to his defense. The exclusion of the composite text message exhibit prevented the jury from seeing that communications between Appellant Adelson and the alleged co-conspirators during the relevant period were ordinary, non-criminal exchanges directly contradicting the state's theory that contemporaneous phone activity reflected conspiracy, solicitation, and coordination to carry out the murder. Simultaneously, the trial court's exclusion of the recorded 2016 phone call barred the jury from hearing Appellant Adelson's contemporaneous expression of belief that the people confronting his mother were not the same individuals who had previously extorted him following Dan Markel's murder. Together, these rulings silenced the most direct, contemporaneous evidence of Appellant Adelson's state of mind, leaving the jury with only selective inferences and post hoc testimony that could be viewed as self-serving. These errors went to the heart of the defense, undercutting Appellant Adelson's ability to challenge the state's narrative and to present a complete and constitutionally adequate defense, particularly because the state capitalized on the errors and relied on the evidentiary gaps in its closing argument, asserting both that, 1, the pattern of phone calls that it was permitted to introduce demonstrated that the alleged co-conspirators were actively planning and discussing the murder, and the excluded text messages would have rebutted this, and 2, Appellant Adelson's testimony about prior extortion was fabricated for trial, and the excluded phone call would have provided 2016 evidence mentioning Appellant Adelson's state of mind relative to the extortion defense. By holding Appellant Adelson's trial in a venue permeated with pretrial publicity and community bias, requiring jury selection from a pool influenced by those biases, and excluding both the composite text messages demonstrating ordinary non-criminal communications to rebut the state's evidence and the contemporaneous recording statement reflecting Appellant Adelson's state of mind relevant to the defense and long before he would have needed to come up with the extortion defense, the trial court deprived Appellant Adelson of a fair opportunity to present his defense, which undermines confidence in the outcome. Appellant Adelson asserts each of these errors, standing alone, rises to the level of reversible error. But if the court determines otherwise, then certainly the cumulative effect of the errors denied Appellant Adelson a fair and impartial trial. See Broomfield v. State, citing Slagle v. State. Conclusion. Accordingly, for the reasons set forth above and contained in the initial brief, the appropriate remedy for all claims is a reversal of Appellant Adelson's convictions and a remand with directions that the trial court conduct a new trial. Signed, Michael Ufferman, Laurel Cornell Niles.